Now, as we told you earlier in the newscast here on the Channel 3 app, there were major developments today with the Sandy Hook school shooting. Several of the victims' families, they reached a settlement with the maker of the gun. There's a lot to break down with this case, with questions about how the maker of the weapon can be held responsible.
And joining us now to sort all of that out is Mike Lawlor, an associate professor of criminal justice at the University of New Haven. Mike, thank you so much for being with us.
No problem.
So obviously a very, very big day. A lot of people have questions about how this all came about. How exactly can a manufacturer be held responsible for the actions of a person who purchases their product?
So this is a big day, and this event is a big deal. It's the first of its kind. I mean, it's not so much that the company is being held responsible specifically for the murders committed by this young man. The company is being held responsible for deliberately marketing assault weapons of this type to young adolescent men with advertisements saying, like, earn your man card by buying this gun. And the plaintiffs here had a lot of evidence like that. And it's that allowed them to take advantage of what appears to be a loophole in this federal immunity law that does not prohibit actions under state law for this type of advertising.
Mike, it certainly sounds like this could have implications for other gun manufacturers, but what about other businesses as well? I mean, to hold them accountable, does this potentially change things more widespread?
No, because the obstacle here was a specific protection enacted by Congress in 2005 that basically, I think it was intended to make it impossible to sue only gun dealers for guns they sold. So this immunity didn't apply to any other type of product. In fact, all other types of products, from cars to refrigerators to toasters, there are product liability laws and plenty of legal precedent which allow consumers to sue them for defective products, et cetera. So the obstacle here was this federal law, which basically said you can't sue gun dealers. However, there is an exception if the conduct was illegal under state law. And under Connecticut law, it is illegal to deceptively advertise in this way, to deliberately attempt to market dangerous items like this to young people who should never get their hands on this type of a weapon.
Also, Mike, correct me if I'm wrong here, but I believe that the insurance company involved is going to be issuing the payout to the families. So how does this happening affect insurance and banking moving forward, and not just Remington and other gun manufacturers?
Well, Remington is in bankruptcy, so but they are still covered by their insurance. And so what I think people are hoping for, at least the plaintiffs are hoping for, is that insurance companies will now look twice when they have to insure gun manufacturers, given the fact that the outcome here was a $73 million settlement. And you can only imagine what those numbers would look like had this actually gone to trial and had a jury been able to render their verdict on what the liability is to these families. I think this is another example where the trial lawyers were able to accomplish something that the politicians were not. You see the same thing with tobacco. This was decades ago when trial lawyers took the tobacco companies to court, got huge verdicts. We saw it more recently with the OxyContin manufacturers and the way they marketed their products to people. So again, credit to the trial lawyers on this one.
Certainly nothing can change what happened that horrible day, but the families have been fighting to make some kind of change, and it looks like they achieved that today. Mike Lawlor, thank you very much for joining us. We appreciate your time.
Anytime.